Ms. Culver, and it relates to the Ambler Access Project. As you know, less than 50 miles of this proposed road is across federal land. The remaining is across state land and ANC-owned land. Can you share with me or explain why the BLM has exerted authority across the entirety of the project area, and really what gives the agency the authority to deny the ANCs the ability to conduct this non-groundbreaking pre-construction activities, the baseline data gathering activities, whether it's cultural assessments and inventories? I know the state of Alaska has directed some correspondence to the district manager there in Alaska. This was mid-November, asking for an answer to the state's request, asking for an answer by today. I don't know whether a response has been sent to that, but can you speak to how you believe that the BLM has the authority here when, again, so much is not part of the federal domain?
Thanks for the question, Senator. I do know that our Alaska State BLM Director is in contact with the state of Alaska, so I expect they are communicating about that request. You know, the process around the Ambler Road is ongoing. We have taken that back from the court, and we have committed to not engaging in or permitting surface disturbing activities while ongoing supplemental environmental analysis in consultation is underway.
I do understand that as it relates to federal land, but again, when the vast majority is state-owned land and an ANC, Alaska Native Corporation-owned land, I don't understand how the agency feels that they have that authority to disallow any non-groundbreaking activities, whether it's cultural assessment, which you would hope would be delegated to the ANCs in the first place.
And our authority that we are looking at is currently, I think what you're referring to, relates to our agreement under the National Historic Preservation Act and the programmatic agreement that's in place that applies to all aspects of these projects. And we are, again, committed to the court to avoid disturbing activities.
Right. And if you will go back to this letter dated November 18th, you'll see that these pre-construction activities have been approved by the state, and they've been determined by the SHPO that these activities will have no adverse effect to historic and cultural resources. So additional conversation about this, but I think it's very clear from the state's perspective, and I think it's very clear from our perspective back here, that the decisions coming out of the agency right now are in direct contrast to what we believe the authorities are.
I appreciate that and look forward to ongoing discussion.
Thank you. Thank you, Mr. Chairman.
Senator